Hey, everybody. Welcome, welcome. My name's Allison Gill. Joining me today from All Rise News, incredible independent media source for all things docket, all things Justice Department. Please welcome Adam Klasfeld. Hi, Adam. How are you?
Great to see you again, Allison. I'm doing well. How are you?
I'm good. I had a week off, and generally, when that happens, a bunch of stuff goes down. We didn't. The Trump administration did not disappoint in this particular case, but I'm
Right.
back now, and I wanted to talk to you to get an update on a couple of things. But I know that you and I both have been watching clips and testimony, where and when we can, of these hearings, this series of hearings on the Hill with the Secretary of Department of Homeland Security, Kristi Noem, and it's not been going well for her. She is getting dragged by both members of both parties over the last 2 days, and a lot of it has to do with, on the Republican side, they're actually blaming her for putting ICE officers in danger and in harm's way for being such a terrible leader and for, costing so much money, talking about FEMA. I know Tom Tillis went after her about that. On the Democratic side, obviously, there's a lot of questions about her integrity, ability to lead, that she should be impeached. Some of her offenses are impeachable. But something that was missing, I noticed, and I know you noticed it too because we talked about this offline, was that nobody brought up directly Tricia McLaughlin, the mouthpiece for DHS up until recently, her lies. I mean, I know Balint brought up their lies in court, but, not the lies to the public. And of course, missing is Kilmar Obrego Garcia, who you have an update on because you recently went to a hearing.
Right. Well, one of the things that was very noticeable to me, it includes Kilmar Obrego Garcia, but it also includes many other people that her office has been going after. This pattern that we're seeing of using official Department of Homeland Security accounts, using her own official account to try to tar people before any trial begins. And this is just become something that is so part of the air, so part of the water, that when there comes to be the time for an oversight hearing, something that's so foundational to any sort of legal system, that if the government is going to try to take away your freedom and trying to accuse you of a crime, you're entitled to the presumption of innocence, and the government has to prove you guilty beyond a reasonable doubt. And no one, even the ones who are very much holding Kristi Noem accountable for many things, the contracts, for Tom Tillis, even what she wrote about shooting her dog, they're going deep there. But the very foundational proposition that you shouldn't try to smear a criminal defendant before a trial, particularly with allegations that you didn't charge that person with. And yes, that counts for Kilmar Obrego Garcia, but that is now routine, particularly with the Department of Homeland Security, where they're showing anyone who they pick up the photographs and coming and. With Kilmar Obrego Garcia, it's an extreme case. They're accusing him of sex crimes that he's not charged with. They're accusing him of being a gang member, even though that has nothing to do really with his criminal prosecution. And even though every judge who has scrutinized those allegations found that it doesn't add up. And the fact that we have official government counts and very few doing it more gratuitously and promiscuously as the Department of Homeland Security accounts. And no one is really defending that particular principle, that you don't use government organs to blare propaganda against criminal defendants long before a trial. It shows how desensitized we are to it and how much that has just become an accepted part of our discourse, that given a lengthy opportunity to challenge one of the worst offenders of that principle, no one appears to be doing it.
No, right. And in any other timeline, that would be something, taking away someone's presumption of innocence guaranteed by the Constitution would be something that every single member of either party should be asking about, since it happens so often. And you're right. I think because the goal of doing it so often is probably to desensitize people to it, and it appears to have worked because it hasn't come up in these hearings, which I think is very odd. But talk a little bit about you. The last time you and I spoke, we were awaiting a hearing on vindictive and selective prosecution, one that had been postponed, agreed upon postponement, but has also been stonewalled by this Department of Justice quite a few times. But we've had that hearing now, and we did not get a ruling. We got a request for additional briefing, as a matter of fact, correct?
That's correct. And to give a little bit even more background to last week's hearing, and I went down to Nashville, Tennessee to cover it. And one of the things that was notable about this hearing was Kilmar Obrego Garcia walked into court flanked by his wife and local activists who had been ushering him from his Maryland home to the courthouse in Nashville, Tennessee. And that's very significant in and of itself because the last time that Kristi Noem was before the Congress, what she said is that Kilmar Obrego Garcia will never, ever set foot on U.S. soil. And he did. He did after winning multiple bail hearings in federal court. He won his release from pretrial criminal detention, and he won his release after that when he was taken into immigration custody. He won ruling after ruling, essentially rejecting the government's attempts to send him to a growing lineup of countries in Africa to which he has no connection. And so that's the backdrop of last week's hearing. And it was a very significant hearing for Kilmar Obrego Garcia because if he wins on vindictive prosecution, not only will he have succeeded in his habeas corpus case, the criminal case could be dismissed. And the hearing, even taking place before anything happened, before any attorney said any word in that court, he started out ahead because the fact that the hearing is taking place means that Judge Waverly Crenshaw has found a reasonable likelihood of vindictive prosecution. And it was the government's burden to overcome the presumption of vindictiveness, and they tried to do so with two witnesses. And those witnesses were a special agent in charge of Homeland Security and just investigations, Rana Sode, and the former acting U.S. attorney for the Middle District of Tennessee, Robert McGuire. Notice who I didn't say was on the witness list. They didn't call Todd Blanche, whose disastrous interview on Fox with Laura Ingraham is why Kilmar Obrego Garcia was able to persuade the judge that a vindictive prosecution hearing was necessary, because it was Todd Blanche who said that he was investigated because a federal judge questioned their decision to spirit him out of the country. That was what Judge Crenshaw found so striking to call this hearing. So they call two lower level witnesses, higher up in this particular district, but they don't go to what main justice's role in it was. And what the accounts that they gave was, well, this was because it was a locally run operation. The head of Homeland Security investigations for the Nashville branch, the special agent in charge of that division, had claimed that she found out about Kilmar Obrego Garcia's case from an article in the conservative Tennessee Star, and that she learned about this 2022 traffic stop where there was body cam footage of the incident. And on cross-examination, you had Kilmar Obrego Garcia's attorneys pointing out that that footage was a source of national coverage before being part of a small circulation local weekly. It was not that the defense attorney pointed out that this was something that Donald Trump himself commented on.
She was trying to insinuate that she just stumbled upon this and was like, "Oh, I wonder what this is about," and reopened an already closed investigation, twice enclosed investigation into a 2022 traffic stop.
Essentially, what she said was she was mailed this article via email by some colleague she doesn't know who. And that's her account of how this investigation started. And then we have Robert McGuire, the former acting U.S. attorney for the Middle District of Tennessee, now the number 2 prosecutor in that district. And his story is that he made the decision by himself without interference from the Department of Justice. But before the new year, I remember us hopping on a Substack Live, very much like this one, talking about the internal communications between McGuire and Todd Blanche's aide, Akash Singh,
Who they
showing
also didn't call as a witness.
who they also avoided putting on that witness stand. And we found out during that hearing that the day that Robert McGuire had gotten the case, hours after he got the case, he receives an email from Akash Singh alerting him to the existence of the person who would become the top key cooperating witness against Kilmar Obrego Garcia. Robert McGuire did not know about this cooperating witness until receiving this email. So it so much
Adam,
emerged
can I
about the
ask you, was that what
origins.
the top cooperating witness, the one of 2 that we learned about during those early hearings to see if they could get a detention hearing?
Exactly. It's the one who is a 3-time former felon, the man who is alleged to be at the top of the criminal conspiracy, and who is receiving help with his criminal sentencing and his immigration. Immigration status, because he was a person who was deported from the United States 5 times, who is now
Right.
the government's star witness against Kilmar Obrego Garcia. There
So
was a
people may remember you and I, sorry to interrupt, but people may remember you and I talked about how odd it is to take the leader of a criminal organization and use them as a witness to and give them clemency to get somebody way down at the bottom of the ladder. That's the guy that we're talking about here.
Exactly. And there was a news story that emerged shortly after Abrego was sent back to the United States for criminal prosecution, reporting that the then chief of the criminal division had quit in protest, believing that this was a decision that was made for political reasons. Well, we found out more about that during the vindictive prosecution hearing. We learned, for example, that this former criminal division chief had memorialized his reasoning in writing, that there
Mhm. A
was
declination memo.
a
Yeah.
declination memo saying why he didn't think that this criminal case should proceed. And he asked Robert McGuire, then top prosecutor in the district, to pass it on to the folks in DC, was how he put it. It was never passed on to the people in DC. Robert McGuire testified that he told people about the decision, but he didn't pass on the memo. And this is the first time we've heard of such a memo. It'll be interesting to see whether this memo ever reaches the light of day. This is someone who was the longtime head of the criminal division in the Middle District of Tennessee, and whose former deputy, by the way, Rasco Dean, is now on Kilmar Obrego Garcia's defense team. He was one of the people who was questioning the witnesses last week.
I was wondering if that's how Abrego's defense team caught wind of the fact of a declination memo. But was it Ben Schrader? Was that the guy's name who quit?
That is correct. Ben Schrader was a former criminal division chief who protested uh, against this criminal prosecution proceeding. He memorialized his reasons, and those reasons have not hit the light of day, at least so far as the memo goes. But it
Yeah.
confirms the earliest reporting we heard about this, about the shakeup that preceded this criminal prosecution. And that's why I'm going to be looking closely for any revelations so far as that memo goes once the post hearing briefings come out on this case.
I'm interested in that too, because that was gonna be my follow-up question, is whether or not anybody had handed over that declination memo in discovery for, and not discovery more broadly, but discovery for the vindictive and selective prosecution hearing, because it seems like it would be some pretty strong evidence, to go toward a vindictive and selective prosecution, but the admittance of the existence of the memo is very interesting, and the fact that it wasn't, it was I didn't transmit it to the guys in DC is also, fascinating, and probably why you don't wanna put somebody like Todd Blanche or Akash Singh on the stand, because they would be asked under oath if they saw that declination memo,
Mm.
and there
Right.
would be a paper trail if there was, because I doubt he flew up and physically handed it to them,
Right.
if he did in fact, send it their way. They'd much rather get, Robert McGuire for, lying under oath if that's the way that it comes down. One last quick question on Abrego. The what do you take, away from the fact that Crenshaw's asked for additional briefing? I believe he gave 30 days, for additional briefing, which is, one side, another side, and a response if necessary, and he gave 30 days. Do you think that's more of a, "This is a very high profile case. Let me make sure I take every possible step to avoid my decision getting turned over on appeal"? Or do you think he actually needs more briefing because of perhaps the Department of Justice's stonewalling, or he wants to give the Abrego team an opportunity to ask or mention that declination memo? What do you take away from that?
Well, I think that Judge Crenshaw has shown himself to be a very careful and cautious judge. I should note that during the hearing there were no oral arguments. There was just questioning of the witnesses. So we have this big evidentiary record. The parties need to have an opportunity to process it, to read through this transcript, analyze what these witnesses were saying. I think everyone knows that if he does throw out this prosecution, one, I have been covering the courts for nearly 2 decades. I've never seen a case dismissed on vindictive prosecution. It's a very rare occurrence. The government would almost certainly appeal that ruling. And so I think that the judge is looking for as much briefing as possible that would include all of the evidence that came into court, all of the arguments for when does it reach the level that a case must be dismissed because it was so clearly brought for the wrong reasons. So, since we didn't have oral arguments, I think these briefings will be an opportunity where we can see all the information that emerged be put together into a coherent narrative, into coherent legal arguments. We might see whether the government will produce the declination memo of the criminal division chief who said no to this case, whether that is going to be an issue that is going to figure into whether this case is ultimately thrown out. But to your question, Allison, I just think that he is proceeding as cautiously and carefully as you would expect for a case of this magnitude, a case that got national attention as we're approaching the 1 year anniversary. We're not there yet, but we're getting close to when Kilmar Obrego Garcia was spirited onto a plane, sent to El Salvador's torture prison, and this whole saga began. And the interest in this case has never really relented since that time. And just as Judge Zinis in the immigration case gave the government every opportunity to show legitimate reasons for deciding to try to send Kilmar Obrego Garcia to Uganda, tried to send him to Eswatini, uh, and Liberia and other countries, and not Costa Rica, which is a country that Kilmar Obrego Garcia agreed to be deported to. We're seeing Judge Crenshaw and Judge Zinis giving the government every opportunity so that if and when this case were to go on appeal, it would be absolutely bulletproof.
Yeah, and it's so frustrating to see the lower courts go through all of this incredible due process and thoroughness and briefing and oral arguments and additional briefing, only to have the Supreme Court often shit all over it by just making decisions on the emergency docket. But that's a whole other show. You mentioned the this all started when Abrego was whisked away in the night in mid-March of last year to Seacoast Prison in El Salvador. Really briefly, there's an update in the Boasberg JGG case. You know, these are the original, the class of the rest of the people who were disappeared to Seacoast. They were then traded to Venezuela in a prisoner swap and set free. And Boasberg came back and said, hey, all of these 140 or so people in this putative class, I order the DOJ to give them an opportunity to get the due process they deserve before they were sent improperly to Seacoast Prison. And surprisingly to me, there were non-zero people willing to come back to the United States, risk certain detention in order to see their due process be given them their due process. Can you talk a little bit about, do I have that right, first of all, and what do you
That
think is going to come of that?
You have that absolutely right. It is worth emphasizing how limited, and this is Chief U.S. District Judge Jeb Boasberg, the judge who has been vilified by Trump's Justice Department and Trump allies on Capitol Hill, who have been talking loosely about his impeachment and trying to discredit him with a rejected disciplinary complaint that was based on
A
absolutely
document that the DOJ wasn't supposed to have, right?
correct, and a document that frankly they misrepresented based on all available evidence that we know about it, which is another story.
Which is
But
why they probably didn't attach it to their complaint. Yeah.
exactly. But what we have here is Judge Boasberg in his ruling, nearly a year after the government spirited these people. And notice I don't say the word deport. Deport conveys some sort of legal.
Legality.
Yeah, I mean, they just whisked these people on a plane,
They
sent
kidnapped
them to
them.
Seacoast Prison in El Salvador, and Judge Boasberg said for the more than 100 who, they're not in Seacoast anymore, but they're in Venezuela and other countries, that you, the federal government, must provide one of two options. You must give them the opportunity to come back to the United States on the U.S. government's dime because, it was their spiriting out of the country was on the government's dime, or you must give them an opportunity to initiate habeas corpus proceedings in other countries. With the knowledge that anyone who returned to the United States because they were unlawfully sent out of the country, that they could be put into detention, new immigration and deportation proceedings could be initiated then while in detention. To your point, yes, I believe I can't recall offhand whether it was 18 or 19, but there were.
I think 19.
I think 19 is correct. Yeah, 19 people decided to go with the option of vindicate their rights to return to the United States, where they knew they would face detention, a new round of proceedings, and we don't know how many others decided on door number two. What the government signaled today is they are going to appeal even that part of the ruling, which was based in no small part on the case of Kilmar Obrego Garcia, because the Supreme Court decided 9-0 that the government had to facilitate Abrego's return to the United States. That was a 9-0 case. And the government's position is now that they have violated the due process rights of these more than 100 people, they don't have any obligations. They do not have to allow them to go back to the United States for any hearings. They don't need to provide habeas corpus. That these are outside of their these men are outside of their jurisdiction, and sorry and good luck. That's the government's position. And that's the position that they're going to try to push in the appellate courts now with this notice of appeal, knowing that the last time they tried to advance that position in the case of Kilmar Obrego Garcia, all 9 justices said, "No, that isn't, the end of your obligations regarding the due process rights of someone who you w whisked and spirited out of the country without any process. Some process is owed. There needs to be some there that, at least in Abrego's case, his return had to be facilitated back to the United States. So
Why didn't the just why didn't the Justice Department argue that the Abrego case is different because we wrongfully sent Abrego, mistakenly, erroneously sent Abrego to Seacoast because he had a no-go to El Salvador order on the books? Why not argue that? Because you'd have to admit that that you wrongfully sent Abrego to Seacoast. Like, I mean, that seems like it's still not a winnable argument, but at least a more colorable one.
I don't doubt that is going to be a distinction they're going to draw. I mean, what we have to put in a little bit of perspective here is that the more than 100 men at issue, most of them are Venezuelan immigrants who were rounded up in the Alien Enemies Act litigation when Trump issued his Alien Enemies Act proclamation that was based on the idea that there was an invasion via Venezuela through the gang Tren de Aragua. Now, we have found since then how few people had any traceable affiliation with Tren de Aragua. With Kilmar Obrego Garcia, he is not Venezuelan. The gang that they accused him of association with was not Tren de Aragua, but MS-13. And they even admitted, to your point, that it was, in their words, an administrative error to send him to CCOT with these more than 100 men.
Well, they fired the guy who said that, and
They
and they haven't admitted it since. Yeah.
Correct. Well, they keep, it's interesting because they admit it when it serves their arguments and they distance themselves from it when it doesn't, because they have gone back and forth a couple of times.
Okay.
Like,
Okay. All right. So they have.
I think that if they realize it is in the government's best interest to acknowledge that talking point, we'll see it resurrected once again.
Okay. I thought that they had kind of totally clammed up about it, but you're right. I think they have brought it up when it serves them, and I imagine they'll do the same here. But like, what a weird argument they've chosen to make. I haven't read the brief yet. I know you just sent it to me, but thanks for coming on and explaining all this. Everyone, Adam Klasfeld and All Rise News do not answer to corporate overlords. They depend on the generosity and support from readers and listeners. It's free, obviously, to subscribe to All Rise News, but if you're able, if you have the means to help, Adam travel around, go to these courtrooms, be in the court so that he can bring us these important details from inside the courtroom, you can do that at All Rise News here on Substack. It would be really appreciated. And speaking of that, Adam, before I let you go, where are you off to next?
Well, I think one of the next big hearings will be right here in New York City. There's going to be another hearing in the Maduro case later in the month. So right now, I'm looking at some of the federal court hearings in my own backyard. I think there's another one that should be coming to a head soon in terms of the clampdown from Trump's State Department on speech when it comes to a researcher of online disinformation. That's another case in Manhattan federal court. So the next live coverage that I expect will be in New York City, where I live. But I'm always seeing what emerges in the news cycle, and if a hearing gets called of national significance, I like to follow the news wherever it crops up.
Yeah, it happens. So just bam, you'll hear about a hearing that pops up. It's always important to be able to go at the last minute. Where you won't be going is Washington, D.C. to hear a case about Biden's auto pen. Apparently, Janine Pirro, according to the New York Times, breaking news that you and I discussed briefly a moment ago, before we jumped on this interview, is that they failed to bring a case against President Biden. They were doing a criminal investigation, Janine Pirro, into his use of the auto pen, and and they said they couldn't put a case together. And I wish we had more details about why. Like, is it because they sat around and said, "Well, he's immune," or "Well, the auto pen's not against the law," or like whatever it was? I would love to have been a fly on the wall for that declination.
It's interesting because it not being against the law or any criminal law has never stopped Janine Pirro before. I mean, fresh off the humiliation of trying to prosecute Senator Kelly and five of his congressional colleagues for accurately stating the law that you do not have to follow illegal orders. You would think that that humiliation and shame would prevent a stunt like this, but we are learning more and more with the news that uh, Pirro is absolutely shameless with that. I point out there was a study that talked about I forget exactly what year, it might have been 2016, but they counted up all of the times there was a no bill from a grand jury, no true bill. And in that particular year, it was six no bills. And,
Six out of
and
69,000, almost 70,000 cases.
right. And that was the number of no bills from, the six criminal defendants. One particular case, she racked up the amount of face plants that the Department of Justice did in that entire year. And she has gotten quite a few other no bills of, famously in the sandwich guy prosecution and other cases. And I talk about it maybe a little too lightheartedly, but there
Mm.
because it's really when we think of she was trying to criminally prosecute six elected officials
Mhm.
for accurately stating the law. And it doesn't get more poisonous than that. It doesn't get more anti small d democratic than that.
But
It's
it will.
absolutely shameful. Yeah, and it doesn't get more anti-democratic than that yet.
Yeah, hold my box of wine. It's gonna come down to that. Well, thank you so much, everybody. Andrew McCabe, former deputy director of the FBI, and I are going to speak more in detail about this failed case against President Biden for the auto pen on this Sunday's podcast episode of Unjustified. It's free to listen wherever you get your podcasts. Again, if you get a chance to subscribe and support All Rise News, please do. And of course, I would love it if you subscribed. It's always free. All the content's free here on the breakdown at MullerSheWrote.com. I appreciate you spending some time with me today, Adam. I know we'll catch up again soon.
I'm looking forward to it, Allison, always.
All right, everybody. Thanks so much for joining us. We'll see you next time.